This video will tell you how to ask to have your court case private. I'm Megan Stewart, a lawyer with Indiana Legal Services LGBT Law Project. Indiana courts are open. That means that anyone can see the documents you give to the court, and court hearings are open to the public. This is a good thing. Having courts open safeguards against injustice by letting the general public see what's happening inside the courthouse. For name changes, having your case publicly available also means having to publish notice of your name change in a newspaper. And these records that are publicly available are not just available inside the courthouse. Many are also available online. In contrast, when your case is sealed or made private, it means your records are not available to the public. No one can see the documents you've given to the court. Your hearing is closed to the public, and your case shouldn't appear online at mycase.in.gov. It's important to know, however, these records are closed to the general public, but they still may be available to law enforcement. Also, if your case is made private, it doesn't mean that you don't ever have to disclose the fact that you had a court case. Judges can make cases private under Indiana's rules on access to court records if you can show what the law calls a significant risk of substantial harm. This risk of harm can be based on violence you've personally experienced in the past or a fear of future harm you have, either from a specific person harming you or from a fear of being harmed if you were outed as trans through the court records. There are 2 steps in making your court case private. 1, filing a written request, and 2, having a hearing. The written request, which includes 4 different forms, tells the judge why you want your records to be private to protect your safety, and gives the judge other paperwork they need to process your request. This is where you explain why exactly having your case be public could cause you harm, either based on your gender or because of your previous experiences with violence, domestic or family violence. This sounds like a lot of information, but the online form helper will make sure your request has everything it needs. After you print and sign the legal paperwork, you file it with the court. You do that in the county clerk's office. Most county clerk's offices are located inside the courthouse. Click the link above for more information. You can also file your request online. After you file the paperwork, the court will mail or email you a notice letting you know when your hearing is. The point of this hearing is to show the judge that you would face the significant risk of substantial harm if your name change was in the newspaper and your court records were public. Going to court can be scary, but you can do it. You'll know the answers to all the questions because they'll be about you. When it's your turn to talk to the judge, someone will call your name and tell you where to sit. The judge will then swear you in and usually start asking you questions about that written request that you've made. This is your chance to explain to the judge why you have that significant risk of substantial harm if your court records were public. You should detail any past experiences you've had with domestic or family violence, or why you have a general fear of being harmed if you were outed as trans through the court records. After the judge is done asking questions, they will most likely tell you if your case was approved or denied. Sometimes they can't tell you right away if they need more information or time to think about it. If they tell you that your case is approved, one of 2 things will usually happen. Either the judge will move right into your request for your name or gender marker change, or the judge will tell you when to come back to have another hearing about your name and gender marker change request. If your case was denied, you can decide to move forward with your court case being public. Just because your request to have your records private was denied does not mean that your name or gender marker change was also denied. You could also choose to apply for legal assistance with an organization like Indiana Legal Services, hire a private attorney, or find another option that's right for you. Keep in mind, if you want to challenge the judge's denial of your request to keep your records private, you must do so within 30 days of when the judge signed that order. To find a civil legal service organization near you, go to indianalegalhelp.org and click No or Low Cost Legal Help.